A federal high court on Friday vacated its consent judgment declaring Drive Obiora Okonkwo as winner of the Anambra Central senatorial district. Justice John Tsoho, who vacated his December 13, 2017 judgment at the instance of an application by the Independent National Electoral Commission, IC, said his court was misled and deceived into giving the said judgment. But Okonkwo in a swift reaction has vowed to challenge the ruling at the Court of Appeal. Justice Tsoho held that having realized that there were 3 judgments of the Court of Appeal on the subject matter, all ordering IC to conduct a rerun for the Anambra Central senatorial district within 90 days, he is bound by the decisions of the Court of Appeal, based on the age-long principles of stare decisis. Justice Tsoho agreed that although Okonkwo was not a party to those judgments, his political platform, the People's Democratic Party, PDP, was a party. Before arriving at the final pronouncements, John Tsoho dismissed all the objections raised against IC's motion for variation of the consent judgment by counsel to Okonkwo, Sabasti Honorable, Son, who was with Festus Kayamo, Son, as well as counsel to PDP and Mrs. Ikwuf. For instance, the judge disagreed with their arguments that his court was futus officio, saying that being a consent judgment which was not based on the merit of the case, he has the requisite jurisdiction to vary it. He further held that he was not bound by the ruling of his brother judge, Justice Ahmed Mohammed, delivered on March 9, 2015, which the plaintiff submitted had not been appealed upon. Justice Tsoho further disagreed with counsel to the respondents that the motion by IC was an abuse of court processes and not competent. Okonkwo had in December 2014 filed the suit a pre-election matter following his substitution with Uchakwuf as the PDP candidate at the primary of December 7, 2014. He said the action is against the provisions of subsection 4, c. 2, of Section 87 of the Electoral Act, 2010, and Part V. Pa. 29, c. e. and g. of the Electoral Guidelines for Primary Elections 2014 of the PDP. The pre-election matter which commenced in 2014 was brought by Okonkwo under Section 87 of the Electoral Act. The said Section 87 of the Act gives candidates or aspirants of political parties who were unlawfully denied nomination, right to approach a court with a view to seek redress. Specifically, during the hearing of the suit, counsel for the first and second defendants and the fourth defendants respectively, Messrs. I.E. Umaji and E.O. Okalai stated their non-opposition to the motion for judgment and also adopted the processes that had been filed by the respective defendants to the effect of not contesting the plaintiff's suit. Also counsel to IC, third defendant, confirmed that his client did not file any counter-affidavit to the plaintiff's matter. He added that the third defendant, as an impartial umpire is not inclined into delving into such matters and that as a responsible organization, IC is ready to abide by the decision of the court. Justice Tsoho consequently entered judgment for the plaintiff and granted his reliefs in accordance with the prayers which arise from proceedings related to the said Anambra Central senatorial district election.